Hey everyone, we are just going to wait another minute or so to allow everyone to filter in from the waiting room.
I was trying to figure out how to take all the wine behind me down, and it just wasn't going to work today.
Wine makes you feel fine.
That's, yeah, after I have those mornings. I've been dealing with our golf tournament all morning, so.
Okay, great, wonderful. Looks like we have a good turnout, so I'm not going to delay any longer. Welcome everyone. My name's Harriett Wessels. I am your CLE co-chair for HYLA. This is our September monthly CLE. Today, we're going to be hearing from our great speaker on contract drafting, and I will let John introduce her shortly. Before we formally introduce everybody and kick things off, a couple of very boring housekeeping items. Please note this is a webinar, which means we can't take you off mute if you raise your hand, but questions are very much encouraged. So please pop them into the Q&A or into the chat. And John will feed them to Samantha-Anne as we go through. If you have anything technical related or any issues with that, please put them in the chat to us as well, and we will try and sort you out. Please remember to self-report your CLE. So we will not report your CLE for you. Please self-report it. You can only get CLE credit for watching this live, and I will put the CLE number in the chat about halfway through the program. So please report your CLE yourself. And we will be putting this program up on the YouTube channel if you miss anything. Thanks so much. I'll hand this over to John.
Thank you, Harriet. Thank you everyone for signing up to join us this lunch hour. So I will do a quick introduction of Samantha-Anne Nadolny, who is probably known to a lot of you, but she serves as the Vice President and Associate General Counsel for Select Water Solutions, a company formerly known as Select Energy Services. This is a publicly traded oil fields infrastructure and chemistry solution company here in Houston, Texas. Prior to her joining Select Water, she served as the General Counsel and Chief Compliance Officer for Citelum US, an EDF group company based out of Paris, France, and Associate General Counsel for Sterling Construction Company, also a publicly traded company that dealt with or deals with road and heavy highway infrastructure based in the Woodlands here in Texas. Samantha-Anne has over 10 years as an in-house legal specialist and a true generalist, handling all needs of the companies that she has worked with in the past and continues to do. She has also been chairman or chairperson of the Board of Trustees for the Houston Young Lawyers Foundation, and currently is a chair of HYLF. She's also served on the HYLA board, and was the committee chair for the Adopt an Angel program. Additionally, Samantha-Anne is a member of American Cancer Society, the Carter Baron Ball, and the Shark Cancer committees. She's also on 3 committees of the Houston Livestock Show and Rodeo, and also on the ABA Lawyers for Literacy Committee. Samantha-Anne lives right here in the Heights with her new husband, Robert, and their 3 cats. Samantha-Anne, please take it from here.
Good morning or afternoon, everyone, depending on where you are. It's felt like it's mid-afternoon here, and so I'm going to actually start my presentation with an apology to all. You might hear some noise in the background. That could range anywhere from loud crashes, smoke alarms, or cats meowing. I am at home today with office under construction and with my house under construction. I took a tree through the center of my house in Hurricane Beryl, and my my current main focus is being my at-home construction manager. So stay tuned for next year's CLE on what a lawyer learns about how to deal with your post-hurricane insurance claim. As John said, I am an infrastructure and in-house corporate lawyer. I have been for about 10 years with a myriad of companies, but I have always specialized in construction, oil, energy, and gas, that industry, very here in Houston. I have been connected with HYLA for a long time, starting as a committee chair, moving to a board member, and then now I'm actually the chairman of the board of trustees for the Houston Young Lawyers Foundation, which is HYLA's sister 501c3 org. So have been around the orgs for a long time, love the CLE and the corporate counsel committees. I think they do a great job, and excited to have you all here today. Far more attendance than I thought on a contract drafting. It's what I do every day, so I don't really consider it super sexy, but it's very important. I'm going to pull up and share screen really quickly. I have a PowerPoint. We're not going to read it exactly. We're going to talk through it, but wanted to give you all that benefit to just see some of the pieces that we talked through, and if you want to take any notes. And as Harriett and John said, please feel free to pop in and give questions throughout. Would love to be able to have that conversation with everyone. So John, can you confirm y'all can see the screen?
Yes, I can see it.
Fabulous. So we're going to talk today about an in-house counsel's perspective on preventing disputes through effective contractual drafting. So the key in this is your job. You sit in an office, you work for a lot of business teams, and you're drafting all of the contracts and the agreements for your group. What does that mean for you? That means not only do you have to get the business piece done, you have to take the project forward, you have to draft this document to make sure you are protecting the client, which the client is your company. So what can you do to not only look at how do I get this project through right now? What do we get to get the business? But also 5, 10, 15 years down the road, even 1 year down the road, how do I prevent some of the disputes that typically I know come from contracts? That's where the majority of corporate disputes come from. They always go back to the document. So what can we do on our side to forecast and to anticipate those events? And how do we draft around that to make sure that we're looking down the pipeline? So there's 2 real pieces, and I'm not going to go into the second piece as much because I think we can have a good discussion on that risk management first. But you're looking at implementing risk management and evaluating risk through claim analysis checks and balancing significant high risk areas. So what that means is you look at your contract every time and you go, where is the risk in here? Your job as in-house counsel is not to prevent all risk. So if you've ever worked in-house and everyone says your job is to make sure this isn't risky, they have no idea what you do for a living. Your job is to eliminate risk where you can. The second piece of your job is to identify the risk and make the business aware of that. So you're looking at the significant risk, but business inherently is risky. That's just part of the game. But what you want to do is you want to try to work around that risk. You want to identify it. You want to make the business aware, and you want to see what you can do to minimize it, or put pieces in place to make sure you can work through it without a legal dispute. So you want to put dispute resolution mechanisms inside that contract in the areas of risk. This presentation originally, when I did it, the scenario at the end that we can go into is for concurrent delays. And so it's assessing disruptions. I do it specifically in construction because that's my neighborhood of contracts lately, and of how concurrent delays, and that's going to be the delays on both sides that are caused and how you resolve those. So love a bit of humor. I always like to say that I'm not a risk manager, I'm a risk assessor. So my projects are successful, and they're more successful long-term when you handle risk management in your contracts. And the key to do that is preventing it at the outset. So well drafting a contract and making sure that you have a really effective document can help protect the legal interest of your business. It builds the better relationships with the other side, the third parties, contractors, et cetera, and it minimizes potential risks that your business may face. You'll see it doesn't say eliminate potential risks that your business may face, because that's, again, not our job. We are not eliminating all, we are minimizing and making mechanisms. So as a corporate counsel, knowing how to draft a contract ensures that your business receives the greatest benefits, and it allows you to defend your company better if you need to. So general counsel and in-house counsels come from a variety of backgrounds. A lot of people started out at a law firm, and I'm sure many of you are at a law firm right now. and you have a specialty. Well, those of us who have been in-house our entire careers, we didn't have a specialty. Our specialty was being a generalist. And as part of that, I'm a contractual generalist, and I specialize, I guess, in the transactional side. And what that means is that, come again? I can draft you a contract. Lucy, I think you are not on mute, unless you're trying to pop in. Okay. So I'm a transactional generalist, which means I can draft you a contract from anything from a 15-year infrastructure contract to a water purchase agreement that extends for 30 days to, an employment contract that details, the future and the piece. But what that is you're always looking and you're always evaluating risk, and you want to prevent that as much as you can. So the key is to start with your general risk assessment. Evaluate your risk at the beginning of the drafting process and walk through with the fact-finding questions. I do this with my business development team. I tend to get an email that says, can you draft me a contract for X about this? It's usually very general, or someone will request a meeting and say, hey, we want to talk through what our next agreement is. I always start with what the contract value is. This is key. If it's a very low value contract, the risk is going to inherently be a lot lower. If it's a high value contract and it's going to be something specific, it's probably something I'm going to want a second set of eyes on, or know that the risk is higher. Same with term and duration. 30-day contracts, a lot less risky than a 15-year contract that is going to go down the hill. So we're looking at those things first of where are we at? What that means a lot of the times on value and term duration is, who do I have drafting this? Is this going to be someone who doesn't necessarily need specialized knowledge and there's not as much risk? Could I have one of my senior counsels or one of my associate counsels do it and then me take a look as I'm teaching this contract drafting strategy? Or is this something that really needs the eyes of someone who's more senior? A relationship is key, because a lot of the times we have relationships with old customers and we have other contracts that we've drafted with them, we've gone through this process. I do love to use things that we have agreed on before. Big corporations have a lot of things that they draw the line on, and they say, we won't agree to this, or these are our standard terms. And so if you have an existing relationship, you can look back at an agreement that you've done and really give you a starting point on where you've already hammered out risk. But if it's a new customer, that's looking at starting from the beginning and where you're at. What type of agreement? Is it a form agreement? Is it a template? Is this a brand new type of project we've never done? I also use type as something that if we have an existing relationship with the customer, because I will look at another customer agreement to see, again, what we have agreed on before. Location is key. As a generalist, you do not, in a corporate counsel, you don't always necessarily have to be licensed in that state. I am licensed in the state of Texas. I did go to law school and I'm licensed in the state of Alabama and was going to take the bar there. So is this something that's new? Is this a state that we work in regularly? Is it a jurisdiction we're familiar with? I sit in Texas and work a lot in Texas, but we operate nationwide. So if I'm looking at a new state or territory, I need to be familiar with what the local ordinances are, what the laws are, and what things could affect that. There are different things that can affect. Certainly, if you're drafting a labor contract in Texas versus in California, that's going to be different. If you're drafting a land contract in Texas versus in New Mexico, where it's mostly federal land, those are things you need to be aware of. It might be something that triggers you wanting to look into grabbing a specialist and hiring someone from one of our wonderful outside firms. Liability. Are there known liability factors? Are you aware? What are some of the things out there? This is one of my favorite examples on liability, but there are a lot of endangered species that you've never heard of. You will never probably hear of most of them again, but there's something called the lesser prairie chicken. It's in the Permian Basin in Texas, and you cannot build or undertake construction during the lesser prairie chicken's mating season or their gestational period. So it is an endangered species. You can't build. They're a burrowing species, which means you can't build a pipeline during that time. That's a known liability for delay of, are we entering into this contract and it's on a very short time and we are entering an endangered species time? So looking at if you have any of those known liabilities. And then also what type of work it is. Is this in our normal scope of contracts or work? Is it something we do? Or are we branching out? These are going to be really where I like to start defining the risk at the beginning of the contract. It lets me know the level of severity and where we are. Gives me an idea of what the entire contract is, where we're at, and where we need to start going. So where can you find this risk in contract? Risk in general is a situation involving exposure to danger, harm, or loss. We see it everywhere. There is risk with me sitting in this chair right now. There's risk with you walking out the door. There's risk with any time you sign on the dotted line. But contractual risk is the chance of facing losses as a result of, one, a party to a contract not fulfilling the terms of said contract, or two, the chance of facing losses from the deal in the contract performing poorly. So that's either non-compliance or non-performance. Those are the two types of people. And there's common types of risk in contract, whether it be financial, legal, or branding. Financial risks usually are credit, liquidity, asset-backed equity risk. These are the risks associated with the loss of money for the contract, whether it impacts your top or bottom line. This can be internal or external. Is this a contract where we are spending money, where we have a line, we need to hit it? Is this a contract where we're worried about getting paid? So there's financial risk, whether it pays off internally on your ROI, or whether you get paid and it pays off as revenue. There's legal risks that arise for breach of contract or legal accountability that result in litigation. And then there's brand risk. This is something people don't tend to think about, but if you default on a contract or a contract goes poorly for a large company, there's a lot of brand risk in the industry that becomes an issue. Do you have a reputation now as someone who broke a contract? Can litigation and legal risk affect your brand? Absolutely, because some of those big litigations become large. It also puts you at risk of not working together with another party and losing industry business. I'm going to switch now and start talking through some of the evaluation strategies. Do we have any questions before I move into that? All right. So treatment of risk and checks and balances are going to be through types of clauses. So your effective contract drafting includes an analysis of the relevant clauses that can check the risk and then balance it with your business goals. As I said, again, we are not there to eliminate all the risk. We're there to evaluate it. We're there to make the business aware of it, and we're there to minimize it where we can. So your essential terms, what are the loopholes? What are the gaps in the commercial provisions? What has the business team put on the table that makes sense for the business? It makes sense for the job, but it doesn't fill in those legal holes. Force majeure is a big one. What does this include? Are we protected in all scenarios? Is global pandemic included in your force majeure? Is hurricane? Is wind? Is endangered species? Is government shutdown? What is the protection that you think you're going to need? What does it include? Force majeure clauses have changed so much, probably in the past just 5 years, that reading those and pulling a force majeure clause that you've had before, one that you signed in 2019 for a 10-year clause may have not protected you through COVID. One you're signing now may not protect you for what happens in 5 years. So looking at how we're wording those. Is it tied to a termination clause? Does force majeure delay the contract? Does it give an option to terminate, or does it automatically terminate? Then we have our termination clauses. Are they effective and useful for our side? Does termination work for the other side as well? Is it mutual? Is there a contingency plan for payment if the termination is against us, or do we have to pay them? What are the areas of terminating for cause or terminating for convenience, and how does that actually become executed? What is the damage and the risk associated with both of those? And then finally, escalation clauses. Have we taken into account where prices can increase and affect the agreement? I keep seeing these memes on Facebook about the price of groceries and eggs and that it's gone up. This happens a lot quicker in the construction in some of the industries that you're taking and contracting for materials than it does at the grocery store. So if you tried to buy plywood and build you a fence in the past 2 months after Hurricane Beryl, probably a lot more expensive than had you tried to do it in April. That's because there's a supply and a demand. There's always going to be the need for the escalation. So have you taken this into account, where in your quote or in what you're putting the cost of this contract is going to be, if you take it into account if it's a long-term contract, how that will affect if those prices, if they double, what if they triple? What if they quadruple and things become very expensive? And so those are going to be the things that you want to look for of how am I now preventing, if I've quoted, and I'm going to use lumber as an example, if I have quoted you a fence for $1,000 and the cost of the wood when I quoted it was $500. Well, now I'm building the fence and the cost of the wood is $1,200. Do I have an escalation process that allows you to pay for materials as long as they're reasonable? Or did I just quote you on a total fixed fee basis? So those are areas and mechanisms where you've looked at the risk, because then you went from making $500 in profit to making negative $200 in profit. Of how do I prevent that risk and prevent that loss for my company? All right. Exit out of this. Oop, sorry. That's me. Y'all don't want to see that. So strategies for treatment of risk. It's kitschy, but I always say that it's an art. And so there are 4 strategies, AART. One is to avoid the risk, resolve it entirely. Again, this is uncommon. Entering into a contract is inherently risky. We don't get to avoid a lot of risk. Where you can, I 100% encourage you to do it. There are bright lines and hard lines a company can take where they say, we will not undertake this because it is too risky. Accept or risk retention is acknowledging the loss from a risk is not great enough to warrant action to avoid it. This is when you say, hey, this could happen, but it doesn't impact us that much, or hey, it could happen, but the chance is so small that we're willing to accept it. We just take that risk on, we don't do anything about it. Reduce is using a solution to potentially reduce your adverse effects. So that's going to be your contract management, your implementation strategies, your continual monitoring. This is when you've accepted the risk, but you've put mechanisms in place in your agreement to reduce it as much as you can so that you're monitoring it and you're aware, you see before it starts to happen. Then transfers, contractual risk transferring are what we use to assign responsibility, whether it be legal, financial, technical, or otherwise, to those risk exposures for one party or the other, thereby relieving one party of that risk. And so we do this through our relevant contractual tools, indemnity and hold harmless clauses, exculpatory agreements, limitation of liability, sub-row clauses, comprehensive insurance, warranties, etc. These are all the fine print in the back that usually occur under miscellaneous. These are probably the most important part of the contract. Everybody thinks it's pages 1 and 2 where you're getting to scope and price. The lawyers need to love the back pages. These are the ones that you need to read with a fine-tooth comb. These are the ones that can affect your contract at the end. So I want to walk through each of these really quickly for you. So the avoidance of risk is a way by just not engaging. It eliminates all your hazards, your activities, your exposures, anything that could negatively impact your organization. And so it's impossible to eliminate everything, but a risk avoidance strategy can help preventing some losses from happening. So to walk through some examples, a construction company might avoid areas severely prone to weather for employees being injured or equipment being damaged. Like a lot of construction companies will not undertake projects in Houston during hurricane season, and I would recommend that right now. They might also not be doing it in Louisiana on the Gulf Coast during hurricane season. A chemicals company could refrain from using hazardous materials or chemicals because of the dangers of handling and storing them. So they might look and just say, we will not use this hazardous material. We will look at other options, but this is a bright line of completely eliminating the risk of hazardous material exposure to employees. And then a sales company might limit the type of customer data it stores on the computers in case of a cyber hacking or data loss. This is huge right now because cyber hacking and data loss and that type of cybersecurity exposure is a hot topic. So a lot of companies are limiting what type of customer data they store on their server or that they retain because the risk is too high. If you don't have the data stored, you can't lose it and endanger yourself. So this is extreme risk avoidance, but it can prevent a business from undertaking profitable opportunities, but it can prevent even larger financial repercussions if you get involved in one of these situations. So avoid risk where you can, but business has to go forward. So a lot of the times we start accepting that risk. Risk acceptance occurs when a company acknowledges that there's a potential loss, but it's not great enough to spend money warranting avoiding it. So if you are considering this, ask, do you have insurance in place for those areas where it could be impacted? What are the risk categories and are they covered? This is looking at saying, I'm going to operate in Houston during hurricane season, but I'm going to make sure I have hurricane insurance. It happens. We are accepting that risk. Have you taken the time to fully understand and the actual risk has been evaluated? Do you know the legal, the financial, the business, the operation? What are the impacts of that? Have you sat down with every department and gone through it? And do you know the true probability of an occurrence? So this is a little bit different of do you plan and accept risk of an earthquake in Houston? Probably so. In California, may not be the same acceptance of risk that you want to have, but what is the actual probability of something happening and looking at what those are? So if you can accept that the probability is low, the risk for you is high, and you have a mechanism to recover in place, you can go ahead and you can accept that risk if the business warrants enough. Reduction and mitigation of risk is an investment in order to reduce risk on a project. So you're looking at processes and methods for controlling that risk. You're identifying it, its probability. You can allocate resources for the management of that risk and really undertake it. So it calls for the implementation of controls. Controls is usually used in a company. A lot of people will say, like, what are your controls? They're referring to SOX controls in accounting, but there are contractual controls that you can undertake too. And so just that fancy way of saying checklist. So what are your actions to minimize the impact of the likelihood? So some examples really quickly for you. On an international project, this is similar to that escalation of price, but companies will often buy a guaranteed exchange rate in order to reduce the risk associated with fluctuations. So this is mitigating the risk that, the dollar takes a nosedive and, the peso or the euro goes up or down based on if you're doing an international project, and that's your terms of payment. You can agree to that up front and say, hey, we're reducing this risk for everyone. We've agreed on an exchange rate. It's $1 to $1 or $1 to $1.25. That's a great strategy for mitigation. A project manager can hire an expert to review the technical plans or cost estimates in order to increase confidence in that plan. A lot of GCs will put together a project plan, not necessarily requiring the use of an engineer, but they might bring in someone externally and use. We do this as a legal project manager per se. We do this a lot when it comes to risky contracts. If I will bring in counsel from the outside that is specialty. So if it is a high level M&A, or I just did a bankruptcy one about 2 years ago, I do hope that it is my last. And if you're a bankruptcy attorney on here, tip my hat to you, because that is one hard area of law. But bringing in someone who can mitigate the risk by having an expert review and really take a look at that, or assessing high risk management activities to highly qualified project personnel is another risk. So this is when you would bring in someone special. You're going to hire someone specifically for that project. You're bringing in a short-term resource. We do this a lot as lawyers at companies where we say we have a project going on and we need to bring in a project finance attorney that really knows this. So this is going to be something that's key. It looks like, do we have a question? Okay, we have the CLE code. So the CLE course code, everyone, is in the chat. It is 174248.
Sorry, Samantha, we don't give it out over because people can't take CLE credit for the for taking it on YouTube. Sorry.
Okay. Redact that then. You don't get CLE if you watch it later.
Sorry.
All right, so our transferring of risk is contractual risk transfer when the language is in a contractual agreement where it excuses one party for financial or legal responsibility associated with specific actions, inactions, injuries, or damages. So when you're drafting a contract, you want to make sure that these risk-related contract stipulations are well written, because that means that they can really effectively protect your company from unexpected liability by transferring risk to the other contractual party. It looks like we have a question. So John, do you want to pose that?
Do you want me to read it out to you to answer?
Yeah, go ahead.
So this question is, I've worked on contracts where vendors have pushed back against including fairly standard mutual contract clauses. For example, mutual indemnification, mutual ability to terminate the contract for the other's material breach of the contract, etc. Mm-hmm. Where they want my company to only be liable for the risk. How do you manage these when you have both the PM stakeholder and your legal manager pushing you to finalize the contract?
For sure. This is the ultimate in-house battle, because this happens all the time. So the business wants to get it done. The other side is taking the hard line. The first thing I do is usually outline what the risk is of the situation to my team. And so getting everyone in the same room on our side and saying that here's our risk, here is what the options are. And then I do love to lay out what can happen for them. And so one thing that everyone I work with can tell you is that if you give me 15 minutes now, I'm going to save you 15 hours of deposition prep later, because that's the key of we're preparing up front here. And so I will talk to them and say, this is the risk and this is the worst case scenario on this. Putting it in dollars and cents and saying this is something that is key is able to get them. The legal department gets to make the call, but I get to make the call on if it's legal or illegal. I don't get to make the call on if we are undertaking business risk or not. And so I get to advise on it, but I am not on the business side. I am a support service to the business. So there are times where we do undertake an agreement, or we look at putting a clause in agreement that I would have liked to draft around, but it is very important to the business and to the overall strategy to do so. So unfortunately, sometimes in those situations, I document that. I put it in a memo to the file of, you know, we do have this risk factor. We were not able to negotiate around this. There is a potential for this to happen long term, but sometimes you have to put it in there if the company is really pushing and they believe it's in the best interest of your business strategy. So unfortunately, there's not always an answer to how you get around it. I always encourage getting on the phone with the other side and talking through. Most lawyers are going to be reasonable and you're going to say, look, I'm happy to cover my side if you're happy to cover your side. I just don't want to cover your side as well. And a lot of people will put in a mutual clause if it's drafted well enough. So I say do whatever you can, but ultimately the business might be the one who makes the call.
Hey, Samantha, I have a follow-up question
Yeah.
relating to risk distribution between the parties. So geopolitical risks are sometimes a major factor, risk factor to consider, especially with international projects or cross-border projects. So in your opinion, which party between the project owner and the contractor is best placed to manage such risks? And what would you look to determine that?
So what I always like to say is both parties are well suited because both parties have their own interests. And so I always think you need to look out for what the interests of your party are. So if you have geopolitical concern, you need to look out for what that is. I think there are a lot of times where the risks are very similar, especially for a contractor and a vendor or a contractor and an operator. And so getting involved in those discussions, the amount of discussions that I have with the other side about being honest about what our risk is and letting them know of this is a concern for us. We understand how this could have significant change or significant effect on the agreement, of sitting down and talking about it. You might be surprised that they have similar concerns and are willing to have conversations about putting in a mutual clause or about contracting around it. And I am very honest with people. My job is to protect my company. I want to get this contract done, but my job here is to make sure that my company is protected as best I can. And so I would say it sounds very menial, but talking about it and always understanding that not expecting the other side to absorb the risk for you or assume that they know your risks, but you knowing your own risks and where your company's temperature is for that is the most important, because you always have to take it on that you want to protect and you want to put the best agreement in place for your company.
And one follow-up to that. So you mentioned that there's always that conflict, or at least a misalignment between the commercial team and the legal team in-house as far as the risks and how to manage risks. So how early, as a legal counsel, would you advise your commercial team to actually start those open discussions about risk? And do you think there is a risk in doing that, revealing to the other side what your risks are, and that would probably be giving up your negotiating position if you do that too early? Is there a sweet spot, so to speak?
Yes. So with the question of how early to get legal involved, I like the business guys to let me know as soon as they're starting to talk about a deal. And as part of that, I actually hop on their weekly call and I listen in. So it's me being involved, but it's in a kind of a passive involvement of it lets me flag anything that I might see or start to think on my side without necessarily being fully involved in the conversation, but being aware. I love to be in the meetings. I love to listen in. A lot of times I'll listen in on phone calls or sit in their office just so that I have an idea and I can start formulating. I think it's a temperature that you have to take of the other side each time. I have other parties that they're aware I'm involved from the beginning because my goal is to get it done as quickly as possible for them. I also have other clients where they're so terrified of legal and they don't want me involved at all that I'm not even on the email chains. And so I think that understanding the temperature of the other side is key, and knowing when it is appropriate. You are an escalator. A lot of the times we will start with someone else. I'll start with a senior counsel being involved and listening and reporting back, because then it gives an escalation piece of They don't see as much threat of, oh, we've got a senior counsel or an associate counsel here. You didn't go ahead and bring in the big guns with your GC or AGC. And so understanding where that temperature is key, and being very aware that not everyone loves legal like we love legal. I like to think that I'm everyone's friend, but a lot of big companies, legal's scary. They don't want to sit with you. They don't want to be friends with you. And so, but internally, I make it clear to my guys, I'm on your side, I'm on your team. Involve me as much as I can, and I'm going to help you as much as I can. When it comes to giving away what our risk position is, every company's been on the other side and usually understands. And so I'm not going to go into it and be like, this is what I'm worried about. These are my top 5 things. Let me tell you everything. But if we're getting down to brass tacks about it, and they're pushing for something, I think you have to give to get. And so if someone is being very unreasonable, or they're taking a hard line on something that I also need to, I'll sit down and say, look, I understand your job is to protect your company. My job is to protect mine. Here is my concern on this. Can you tell me, if I'm telling you what my concern is and why this clause doesn't address that, can you explain to me how you feel it's being addressed elsewhere? Can you feel how I can get a little bit of comfort on this, or let's talk through what some of the options might be. I also usually try to bring a middle piece and have a couple of layers of what I say of, this is something that this would make my team feel better, and we can give here. Or if we tweak this, what this word is. I don't know if there's any Crown members or Crown watchers in here, Crown on Netflix, about Queen Elizabeth, but there's a fantastic scene about negotiating where she's going back and forth with an entity, and they're going back and forth on one word, and it's whether they concede, or whether they give, or whether they agree, or whether they discuss. And so sometimes bringing your word, it may not have a huge piece to what the other side thinks, but it may be enough to acquiesce you. So not only do I like to address it, I give them something so that I can understand where they're coming from, but I also like to bring a solution to the table that is a step in my direction, but maybe not necessarily a full swing.
Thank you.
Anytime. Any more questions before we talk about transferring risk language? Okay. So we addressed it a little bit, but contractual risk transfer is when language, excuses one party from financial, legal, or responsibility associated with action, injury, or damages. And so when well written, these can protect your company from unexpected liability, because it literally gives that liability to the other party. This is kind of what we were talking about of where do you get? This is that one-sided hard line end of the contract language that is the most important. So transferring the risk is directly affected by the clauses. So let's talk about some of those contractual tools. One, John discussed indemnity. A clause secures a party against legal actions for their actions. So if you agree to hold harmless, secure, and indemnify a contract, you are off the hook. We love a good indemnity, but indemnities can be written where you're holding harmless for just this. One of my favorites is trespass. And so if you're holding harmless for, entry onto a property, are you holding harmless for everyone, for just employees? What about contractors? What about people associated with? What about third parties that they hire? What about people that break in? What about the landowner that accidentally hurts themselves because they're on there? So depending on how you draft it, if you just hold harmless for anyone that is on that land during the time that you're under a contract, that's a little broad. But if you put it for just your employees, that protects, it transitions some of that risk, but it doesn't expose you to potential other options. A hold harmless clause is usually included in an indemnity. It absolves one or more parties for a contract of legal liability from injuries or damages suffered by a party signing the contract. So you always usually hear we indemnify and hold harmless. Those go hand in hand. An exculpatory agreement is part of a contract that prevents one party from holding the other party liable for damages related to the contract. So if there are one of my favorite exculpatory ones is typically, and this is in the construction realm again, is if there's injury to the contractor party where they're actually doing the work and an employee gets, there will be an exculpatory that doesn't hold the owner or the general contractor liable for those damages that are related to the contract. Limitations of liabilities are provisions that limit the amount of exposure a company faces in the event a lawsuit is filed or another claim is made. We love to do this, and we love to put in a limitation of liability that no claim can be greater than the contract value. This is great when the contract value is $100,000. This is not great when the contract value is $60 million. So you have to be careful in this situation on this one, but you can limit your liability to a certain amount. Waiver of subrogation clauses prevent insurance companies who then step into the shoes of the insured from suing the other party to the contract. This is good because you can do a settlement between parties, but then the insurance company can come back for them. So if they make a claim and you make a claim against your own insurance, insurance can't then turn around and sue you. We like these when there are limitations of liability because if there is a claim where, say, an owner and a contractor have a dispute, they settle to a limitation of liability, the owner then files it against their own insurance policy. This would prevent the insurance policy from then going back and suing that contractor for more or for restitution. That's key. They do that. You probably don't even know when your insurance goes for subro. We see this in medical a lot. Comprehensive insurance requirements help pay or reimburse for any and all situations or name an additional insured. I apologize. You're about to hear some beeping because apparently this is the exact moment when my fire alarms have decided to test themselves in a construction zone. So comprehensive insurance is great. You want to make sure that you are transferring this and helping pay or for all contemplated situations. We require everyone to have comprehensive insurance, and we do list certain amounts based on project. So we will say you need to have certain amount of auto, certain amount of workers' compensation, certain amount of general liability, certain amount of umbrella, and that protects you based on what the potential value of the contract could be. Then finally are warranties. Warranty statements made by the warrantor regarding the existence or accuracy of facts, condition, quality, or nature of a good, service, or property. If you are buying something, for example, say you're buying a generator, it comes with a warranty that it is used for a specific purpose to provide power to X. That is a warranty that they're giving. If you get the generator, you then plug it in and it doesn't work for that purpose, the warranty will have them replace that. We also tend to have construction warranties where this property or this building will not have any defects for a year, 2 years, etc. This does prevent you from, if day 2 something collapses because it wasn't built right, you are able to go against that and take that warranty. Any questions on transferring of risk and the relevant contractual tools? Because we are wrapping up, so I'm not going to probably take your whole lunch hour by going through scenarios, but happy to address any questions. I've got some example indemnity provisions here of just, who has obligations, what triggers it, what's covered, what limits apply, are there exclusions, who controls the claims, what if there's a dispute? Warranty clauses, again, what does it cover? What will you do to correct any problems? How long does it last? What's the potential cost? What does it cover or exclude? What is the time? What are the state laws? Does it pass on to a third party? This is huge for if you're paying someone to market or you bought that generator from a contractor, but they bought that from the generator company. Does you as the third party get that original warranty extended? So these are all key things you want to look into, that you're drafting these clauses and they're included, but there are pieces around them. So questions, concerns?
I do have 2 questions.
Yeah.
I'm not sure if anybody else listening in has questions. If you want to post them, now will be a good time. But while we wait to see if any other questions, I have a couple questions. Samantha-Anne, how do you see AI evolving in the arena of risk management in contracts?
I see AI as a great tool, but I also see that it could potentially become a crutch. So AI has a lot of information that it's going to be able to provide when you're evaluating a contract. I anticipate and know there are softwares out there where you can run a contract and it's going to show you your risk. The thing about AI being risky for you is that it doesn't know your business like you do. So I always say that AI cannot replace someone being great in knowing their industry, because AI has to learn, and that is the key about it. And so I think that it is going to be great in spotting some initial things, but it is still going to need that personal application of you to talk to your business teams and determine where your risk tolerance is. AI knows what risk is, but AI does not know your business's risk, temperature, and tolerance.
Okay, and I have a question that has been posted. At what point do you consider dispute resolutions in contracts or clauses in the contracts?
Early, all the time. And so we include this when we're usually doing a first draft of what do we want to have? Is this something that we have fear of litigation? Is this something we want to put in an arbitration? We consider that pretty early. We always, and certain companies have different tolerances. I've worked internationally, and internationally, they prefer to put something in that usually is in the international arbitration courts. And so we'll put in a clause for that. Some places don't mind litigation. Some places both waive their right to trial. So we consider that very early in. Prepare for the worst, hope for the best. And if you put it in there, then ultimately, you know, at the end, there's never a question of, am I getting sued if I have one of those clauses in my contract? If you have something where you both waived your ability to file a lawsuit and go to arbitration, you're not getting sued. It doesn't mean there's not going to be a dispute, but it means that you understand what the risks of that dispute are.
Thank you. I have another question here. So our company will carve out indemnity obligations from limitations of liability. However, we have encountered situations in which the other party wants to limit their indemnity. Any recommendations on how we can address this?
Absolutely. This is probably a situation where you're going to see knock-for-knock indemnities, which are that you cover your own. That's pretty common. Knock-for-knock is mutual. There are certain states that don't allow knock-for-knock, Oklahoma being one of them. And so just being aware of where your local jurisdictions are and what their treatment of knock-for-knock indemnities are is going to be key. But I do think I always tell someone, if you're going to limit your liability and indemnification, so am I. And I think that we should be able to do that. So if they are really pushing hard, a good way to approach it is very reasonable and say, great, you take yours, I'll take mine, we'll cover it all.
Okay, another question here, not so much a drafting question, but how do you get around in-house counsel or legal being called or known as a bottleneck or roadblock to the business or the sales?
It's the ultimate question. I could keep you here for another hour on it, but I won't. I've always considered myself a friend of the business, but that is probably the hardest thing that you have to work at regularly, because your job is kind of to be the bad guy. But as part of that, I think it really takes a lot of team building at the beginning. And so when I start a job, and I've been at Select for about 4 years, and you will, it is not news to them or news to a lot of people on the call, but you will be seeing an announcement soon where I am making a transition. So surprise, it's semi-common knowledge now, and my company does know. But you have to go in with the knowledge that legal is not liked. Most people are scared of legal because their experiences are usually personal and not work. So the only time people deal with lawyers are when it's bad. I have to make them and show them that you dealing with legal is part of the process and it's good. And so becoming part of the nomenclature and the general process is key. I work really hard up front to learn the nature of the business, to be able to talk to them. It's key if your business guys can talk to you in business terms. So when they come in, they don't have to dumb it down for me. I can talk to them in business and understand, and then draft a contract because it doesn't waste their time. But I always let them know, hey, I'm here to help you. I'm here to do that. In learning and earning their trust is key. And so pointing out the good things as well, it helps them understand that you're there to learn. I also regularly offer to be the bad guy, which I think a lot of lawyers do without knowing it, but I make it very clear. If there's something that they know and they say like, oh, they're not going to like this, it's going to be tough. I'm like, do you want me to break it to them? Like, I'm happy to take that blame. I'll be the empty seat. You can blame this on me and say, God, our legal department is so strict and they're awful and they don't know that. It keeps the business relationship that the guys are having together, and it resolves the blame to you, because to the other side, I can be an empty chair and the business team doesn't take the hit of, well, you don't want to get the deal done. Their key is that they want to get the deal done. So I'll take the blame for them, and I'll let that brunt be directed towards me and help them where they can of communicating, making effective deadlines, but showing them ultimately, I'm on your team. My job is to make sure that you get this job, because if you don't get a job and you don't succeed, I don't have a purpose and I don't have a job either. So starting to learn the business, earning their trust, and showing them you're on the same side is going to be the key. It's hard. We're taught to kind of keep that that divide between business and legal that I think is tough, because you want to have that respect, but they're going to respect you more when they know you're working for them and with them.
Okay, I have one follow-up question with
Okay.
respect to the relationship between legal and the commercial team in-house. A lot of times you get to hear that, well, that's a commercial concern, let the commercial team deal with it. How involved are you in some of the commercial decisions? For example, you mentioned after a hurricane, if you're going to be buying, lumber, it's probably going to be more expensive, or something like that with material price risk. So how involved are you with such commercial decisions that go into contracts? I'm thinking more towards the type of compensation model that you use in contracts, and the various contracts, whether it's going to be lump sum or reimbursable, cost plus, whatever. How involved is legal as far in your experience as far as that's concerned in contracting?
So I always ask those conversations and those questions up front of, what's the price structure, or what's the piece of this? I am not going to tell the business team, there are times where I'm like, this is commercial, that's fine, do it. Y'all put this in. But there's legal repercussions to every commercial decision. And I approach it from that side of, if they say, hey, we're going to do this as a fixed fee project, and I say, great, okay. Just so you know, there are things that we're going to have to include in here, and can you get this done? And I use the worst case scenario approach often in this, of where I'll say, if this is a fixed fee contract and it's on a set timeline and you are 1 day over, what if you now have liquidated damages? And so I'll let them know what the prices and the options can be. And so we'll have the conversation not about why it's not a good idea, but about what the risks are associated with it. And there are times that I'll go, yeah, guys, if this is delayed by 1 day because the cost of lumber goes up or anything, and then now your price starts to show, on the business side, showing them the money is usually the way to go, because their jobs, their profit, and usually their commission for business guides are set based on what the margins of the project are. And so pulling up the model and saying, great, so if your lumber costs increase 50%, where does your profit go? And they go, well, it goes to zero. And it's like, we could put another mechanism in place, but bringing to the table too another option of saying, hey, if you put this at a cost plus fixed fee of, you've got a fixed fee for the construction, but you take out the costs, now your margin maintains. So bringing effective solutions that don't have legal repercussions that then cut into the profit, that's the way to their hearts. Their way to their hearts is through the dollar signs. So if you bring it of, you just can't do this because this is a bad idea, that's not the right way. You shouldn't do this because it will impact your profit, is a more effective way to speak their language.
Thank you. I like that quote. I'm definitely going to be using that, hopefully. Not as often, but I like, there's a legal repercussion to every commercial decision. So yeah, I like that. I think we have come almost towards the end of our time. I don't see any other questions. I'll hand it over back to Harriett to close out. Samantha-Anne, thank you very much for this presentation. This has been very educational for me, and I'm sure for the rest of the people on the webinar today. Thank you for your time, and thank you for all you do for HYLA and for HYLA.
Thanks to you all. I always love the opportunity to chat with HYLA. If you are interested or want to continue the conversation forward, I am happy to chat. You can find me on LinkedIn, Samantha-Anne Nadolny, and I'm available on the foundation website. Would love to see you all at an event soon.
Harriett, before I fully give it back to you, Samantha-Anne, are these slides going to be available to us? Or you hold them closely?
Yes, we can. I'll go ahead and I will export a PDF of it to send to anyone who RSVP'd, and we'll get that out. It may not be this afternoon because I have a meeting right after this, but it will be within the next day. So you'll get one.
Thank you. Harriett?
Thanks. Thank you so much, everyone. Just a couple of items. Samantha-Anne and John, thank you so much. This has been really fun. It was really nice to have you both kind of interacting and people asking questions. We had a really good turnout, so I really, really appreciate it. Again, Samantha-Anne coming through and giving us the most fantastic presentation. Always wonderful humor, and I think it's really engaging. So I really appreciate it, and also really fantastic to be able to collaborate with the Houston Young Lawyers Foundation again this year. With that, I just wanted to say, please check the chat for the course code if you joined after I posted it, or if you just weren't paying attention to the chat because it was such an exciting presentation and you were thoroughly enjoying it. So I'm just going to leave that up for a minute while everyone exits and gets on with their day. But yeah, again, thank you so much, everyone. If you have any questions about CLE or CLE committee, please email me. You can find me just by Googling my name, it pops up. So thanks very much. We'll see you next month.
Thanks, everyone.
Thank you. All right.